Okay, class, Chapter 2, Part 1. Okay, let me see if I can get this a little straighter. Think that's better. Okay, so Chapter 2 has to do with business in the Constitution. That is the Constitution of the United States. Remember that we also have a state constitution, but right now we're talking almost exclusively about the U.S. or federal constitution. Okay, so we begin with the concept of the Constitution being the supreme law of the land. That is found in the Constitution itself and reiterated in multiple U.S. Supreme Court decisions. Anything that conflicts with the U.S. Constitution is null and void. So any federal statute, any state statute, any state constitutional provision that conflicts with the U.S. Constitution is void. Neither Congress nor any state may pass laws in conflict with the Constitution. So we talked about this before, but the concept that we have in this country, created by our Constitution, is the concept of federalism. It was a compromise that was reached by the founders, by the creators of the Constitution, wherein the federal government and the state governments share power. As I've said before, the Constitution sets forth the powers that the federal government has. Anything that's not specifically given to the federal government is reserved to the states, and the federal governments cannot legislate in that area. However, the federal government does have implied powers to undertake actions necessary to carry out the powers that they have been expressly given. Okay, so each state has sovereign power. And states also have what are called police power. Okay, police power are the ability to regulate certain affairs within their borders. This usually means that states have the right to make laws for the health and safety of the citizens of that state. States also retain the power to regulate intrastate commerce and some interstate commerce that occurs within their border. Okay, intrastate commerce means commerce that occurs within the state. Intrastate means something that occurs between that state and another state. As I said, these police powers involve public health, public safety, public morals, and general welfare, and include things like environmental, corporation, property, zoning, and domestic relation laws. So in effect, we have a government at the federal level, and then we have 50 separate state governments. The powers that are given to the federal government through the Constitution are called enumerated powers. The Privileges and Immunities Clause, found in Article 4 of the U.S. Constitution, states that citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. So we're not going to discriminate against you based upon what state you're from. It prevents a state from imposing unreasonable burdens on citizens of another state. And you go into the standard that is used there as well. Okay, one of the key provisions of the U.S. Constitution, found in Article 4, Section 1, is the Full Faith and Credit Clause. This ensures that any judicial decision with respect to property rights will be honored and enforced in other states, and also requires that full faith and credit be given to the legal rights of American citizens as they move from one state to another. It applies only to civil matters. So an example is if you get married in Indiana and you move to Georgia, you don't have to get married again in Georgia in order to have a legal marriage. Georgia has to recognize the legal acts of Indiana in marrying you. The only exceptions are very narrow, and those are where the law from the other state would be contrary to strong public policy within the state in which you have moved or you're seeking to have the laws given full faith and credit. Separation of powers. As you know, the Constitution sets up three branches of government and separates the powers that the government has into these three branches. So we have the legislative, executive, and judicial. The legislative branch creates laws, the executive branch enforces laws, and the judicial branch interprets laws. Okay, so this creates a system of what we call checks and balances in order to prevent the government, any part of the government, from becoming so overpowerful that we're living like we were under British control and have those kinds of problems. The writers of the Constitution set up these checks and balances. So each of these divisions of government can provide a check on the other branches. So, for example, if the legislative branch passes a law, if the executive branch, the president, doesn't like the law, the president can veto that law. If the president likes the law and signs it into law, the judicial branch has the power to declare it unconstitutional if it violates other provisions or violates provisions of the Constitution. If the president takes action and Congress doesn't like what the president did, in many instances the Congress can pass a law that limits the president's power unless those powers were directly given to the president through the Constitution. The legislative branch also has the power to limit the president by the power of the purse, that is, by Congress having the power to set the budget. They can take away budget from the president in that particular area and limit or deny the president that action. And again, the judiciary has the power to declare that president's acts unconstitutional and prevent them from being put into effect. Finally, if the judiciary, through the U.S. Supreme Court, or actually even lower courts, does something and the president doesn't like it, the president can attempt not to enforce it, to have it not enforced. Okay? Another check on that would be that Congress, if they don't like what the Supreme Court has done, then they can either pass a law that overrides that, or if it impinges upon the Constitution, they may have to pass a constitutional amendment. But that's how checks and balances work, and you can see that here. Okay. So, now executive orders have become very common in recent history. One could argue that that's a result of having a Congress that is so divided that it doesn't get a whole lot done, and presidents have used that as a reason to issue executive orders. And executive orders are basically orders that the president makes to the federal agencies that the president has control over, and orders them to do something or not to do something. Okay, so one of the key things with our judicial branch that occurred early on in our history occurred in the case of Marbury versus Madison, probably one of the most, if not the most important Supreme Court case that was ever decided. And what Marbury versus Madison held was a very basic concept, and that was that the Supreme Court of the United States is the ultimate decision maker of what the Constitution means or how it's to be applied. Interpretation of the Constitution. So without the decision in Marbury versus Madison, you could probably wipe out 250 plus years of judicial decisions by the Supreme Court interpreting the Constitution. Where would we be? I don't know. It sort of leaves a vacuum. But there are people who did not agree with the Marbury versus Madison decision. Nevertheless, it's good law that's lasted a long time and will probably continue to be there. So we talked about the supremacy clause in the Constitution, which makes federal law supreme over all other law, and the U.S. Constitution supreme over all law. And we call that preemption. That means that those laws adopted by Congress or those interpretations of the Constitution by the Supreme Court preempt any laws that conflict with them. Okay, now the last thing we'll talk about in this part 1 video is the Commerce Clause. Now, an important concept for you to remember is that the federal government can only make laws that they are allowed to make based upon the Constitution giving them that authority. So there's a handful of provisions in the Constitution that authorize the federal government to make laws. There's a specific one that authorizes the federal government to levy taxes, okay? And there are several other specific ones. But the most general one, and the one that has come to be the constitutional provision that has authorized Congress to make the most laws, is the Commerce Clause. And the Commerce Clause says in Article 1, Section 8, that Congress is empowered to regulate commerce within the foreign nations and among the several states and within the Indian tribes. It has the greatest impact on business than any other provision. So, the Commerce Clause initially was interpreted by the Supreme Court very narrowly, and it basically said that the actual law had to somehow directly affect commerce in order for it to be legal, and in order for it to be allowed under the Commerce Clause. Many years ago, the Supreme Court changed that interpretation and basically said that anything that even indirectly affects commerce is authorized to, by the Constitution, to be something that Congress can legislate on. As a result of that, Congress today legislates on many various areas. So, for example, one of the civil rights era cases that occurred in Georgia had to do with desegregation under the Civil Rights Act, which prohibited businesses from denying services to blacks. And the court ruled in that case, which dealt with, I believe, a cafeteria or a restaurant that had a policy of not serving blacks, that even though their customers were essentially within that state, it still had an effect on interstate commerce because of the food that they serve coming from other states, etc. So that it was a reasonable law under the Congress's power under the Commerce Clause. Now, I like to emphasize the Commerce Clause in my classes because I use it for a number of reasons. One is that I like students to understand that the law is ever-changing, and that what the law is today may not be the law 50 years from now, even major decisions. So there are many legal scholars and lawyers who do not like the broad interpretation of the Commerce Clause and would like to change it. And with changing members of the Supreme Court, it's always possible that either we will go back to a very narrow definition, or that there will be exceptions made to the general interpretation. And we've seen that in the last few years with 2 or 3 cases where the Supreme Court has said that Congress has gone beyond its power under the Commerce Clause and struck down those laws.